afternoon, and welcome to a continuing series in the Public Law Center's presentations on access to justice. Today we're going to have a panel on collaborative divorce and how that is working within our community. I'll let the panel members introduce themselves, and thank you for being with us today.
Okay, thank you. My name is Janet Harley. I'm the current chair of a group called the Nevada County Collaborative Practice Group, which is a group of attorneys, mental health people, and financial neutrals who are working to establish collaborative practice in divorce in Nevada County. And on my left is David Harley, who's a mental health professional, Marilee Nelder, another attorney, and Rebecca Pally, also a mental health professional. We represent the group, which you can find online at nevadacountycollaborative.com if you want to know more about all of the membership and a little more about the organization. We started this group only about a year ago, partly in response to the fact that we realized that there are no family law lawyers who litigate their own divorces. And if you think about it at all, no one knows better than we do, and the mental health people, just how destructive the process is. And if you know any divorced family law lawyer, my guess is that they did not take it into court because they knew they needed to avoid all the stresses, the lack of privacy, all the things that go with litigating a divorce. And so, for me at least, that was part of the impetus. Divorce is not the end of your relationship with your spouse. All it does is change your relationship from one where you're living in the same house to one where you're in two different houses. And your parenting issues become far more complex, as well as all the other issues that go on in your life that you have been dealing with before as a couple. So I'm going to turn it over to you.
Okay, I hope you each have an outline of what we're going to be talking about today. I'm going to start by talking about some of the attitudes and intentions that are necessary for the collaborative divorce team process. And there's a recent book that's out called Mistakes Were Made, in parentheses, but not by me. That's the title of the book. And it takes a look at political arena, personal arenas, and how busily we as human beings are at justifying ourselves when we find ourselves in a pickle. And it's so human to dig in and shovel blame when we get into some kind of difficulty. Or we can choose a new path, and that is to learn and grow. What are some of the attitudes that are essential in terms of working collaboratively for a couple to come apart? Respect. You don't need to like someone in order to respect them. Respect is an essential kind of attitude. Civility rather than blame, payback or revenge. It doesn't mean that those feelings might not exist, but a commitment to and an intention to operate in a civil with civility and respect is important. Look, the collaborative process helps the people participating look at not only what they say they want, but how their behavior helps them accomplish what they want. So often we as human beings, when we're in a relationship struggle, say we want something, but our behavior seems to suggest something else. Revenge, payback, some way. And so the team assists people to really stay focused on an intention to solve things in more civil and humane ways. It's very much an intention to participate in a process. I'm going to talk about that later on in the presentation today. Certainly the intention of safety for all is a very important one. Personal responsibility. We as a team certainly take the position that while each of us intends to be responsible in carrying out the roles we have, we ask the couple to take a central role in being responsible to honor their intentions and their commitments. And that really involves relying on strengths and building on strengths rather than focusing on blame and pointing fingers and looking at the weaknesses that we think we see in our soon-to-be ex-partner. The next focus, and you may have questions as we go along. If you do, please jot them down because we are going to have time. We hope to allow 15 minutes at least to respond to questions. We'll want them focused in a general way, not in terms of specific individuals, okay? That would be important to remember. Our next, what we're going to be focusing on now, is what are the roles that each team member takes. There are a number of roles in this process. And the role, they're the couples. The couple has a role. Each person has a role. There's 2 attorneys. There's 2 divorce coaches. There's generally a financial specialist, often called a financial neutral, meaning that they don't advocate for any position. They take a neutral position, providing and bringing in for very specialized and important information. And then as well, often a specialist who focuses on the child's needs. So we're going to talk about all those roles. We're going to start by talking about the couple, and Marilee will be talking about that.
I think it's interesting that we need to really keep focused that the parties, the people whose lives are involved, are team members. I've focused as a family lawyer for many years on telling the clients that they're part of the team, as are the various support people in my office. But that becomes even more critical in the collaborative divorce process. And it's kind of interesting that the only people who have no training in this process are the central members of the team, and that we keep that focused on that. There are basically 4 divorces going on at roughly the same time. Sometimes not, but that creates other problems. There's the legal one, and that's in many ways the most straightforward. The financial entanglement and separation that is related to the legal one. And then there are social and emotional divorces. The social one is the interactions with other parties, family members, getting used to doing things as a single person rather than as part of a couple, cultural components, and then the emotional internal one. The parties whose family is being restructured are the only folks on the team who are actively participating in all 4 of those. And they need to be supported by the team members in doing this. It's their life, it's not our lives. As much as an attorney, I've on occasion internalized my client's problem and focused on that. It's important to remember that these are the folks that get to make the decisions and have to really live with the consequences of the decisions. It's, let's see. They have, well, I'm not sure if I can do much more on that without repeating myself, but to keep in mind that the parties are team members and need to be included as part of that.
The attorney's role in this is far different than the role in litigation. The attorney first has an obligation to make certain that the parties know their rights under the law. But then we also spend a great deal of time not restructuring necessarily, but attempting to talk about universal goals rather than parties' positions. We want the parties to be able to think in terms of goals that they both share. For example, one party going into litigation may say, I want the kids living with me, period, and visiting, that's line back. The other approach might be, we would like our children to have the best possible relationship with their parents as they can, without going into any discussion really about prior activities or prior concerns. We are at a new place where the problems that go with the divorce and separation are the problems that have to be solved. And you talk in terms, instead of support and somebody wanting the most support they possibly can get, to look instead at creating a budget so that both households can run as well as possible. And so we attempt to help people start looking at a bigger picture so that the decisions that they make are going to be more useful for the family as a whole than just for themselves. And that's not a particularly easy thing to do, especially when the parties leave our offices and go and talk to their friends or get their main legal advice from the person who cuts their hair and or the neighbor who had a divorce and everything fell apart. One of the things that I ask people to do is to let their friends and their family know that they've made a commitment to do a different kind of divorce, and that talking to them about being self-protective is not going to be particularly helpful in the process. And whether the outsider agrees or not, they can respect the participant's desire to at least try this at first. And so the attorneys try to help the parties frame their decisions based on the greater good of the family, and still making sure that all the legal issues they must address are actually addressed. The attorneys actually take a larger part in establishing the agendas for the meetings in consultation with their own clients than do the other participants in the team. And Rebecca, if you go there with the divorce coaches.
Okay, I'm going to talk some about the role of the divorce coach. In the collaborative divorce process, each spouse has a coach who is a mental health professional who's specifically trained in the divorce process. Each coach is an ally and helper of the divorcing partner that they represent. They get to know that person, and they have the task of helping that person be the best that they can be, both in the process of divorce and after the divorce. We help them privately often, as well as in meetings together with attorneys and partners. This helps them to be able to better function in the legal meetings and the coaches' meetings. The coach works, coach works during the process of the divorce, trying to help the partners communicate in a way that moves the process forward and minimizes the potential for defensiveness and animosity. Experience has shown that if a single coach tries to help both partners in the divorce, it's common for one or other of the parties to imagine that the coach is siding with one person against the other, and that makes it impossible for the coach to be effective. In addition, when two people are at very different stages in their emotional recovery from the loss of their marriage, which is quite common, or they have very different values and perspectives on parenting issues, it helps to have a trusted ally who can help them state their concerns and give them supportive help at precisely the right moment during the meetings. A single neutral person can't do that job either. Collaborative divorce coaches help the partners to separate, unlike marriage counselors, and to learn communication skills that do not depend on intimacy, and to build their lives apart from each other. To be done well, much of this work must be done separately, each partner. Coaches provide emotional encouragement. They teach stress management and communication skills. They explore parenting concerns. And they help ensure that both parents or partners' needs, concerns, and feelings are understood and expressed in constructive ways. Coaches help partners recognize and change unhelpful communication tactics. They use an efficient, structured process for building up each partner's competency, effectiveness, and resilience, all of which are often diminished during the divorce process.
I'd like to comment a little bit, add to that a little bit as we think about both the attorney and the couple and the divorce coach. Often when people move into a divorce, their vision becomes what we might call tunnel vision. Instead of being able to see the big picture, that we narrow and see smaller and smaller things when we think about positions. And it's the job of the attorney and the divorce coach to use the skills that Rebecca's talking about to regain a larger picture. Jan, I know you've talked about the couple that's who both want the same orange. Could you talk about what one might do when two people want the same orange? That's the best orange in the pile, and I want it.
Well, okay. A hypothetical here is if two women are in the market and they both want the last orange. By discussing with them what they want to do with the orange, you may well be able to find an answer that will solve both parties' interests. Meaning, you learn from this that one party wanted the pulp to make into juice, the other one wanted the rind to use the zest for flavoring. And you can take up one orange, solve the problems, and have people walking away happy. And that is one of the prime examples of what we are trying to do by broadening the scope, looking for differences between the parties, what it is that they want to accomplish. If they're different enough, you might be able to accomplish everything on the list for everybody.
Thank you, Jan.
Oh, sure.
And that moves us right into another very important role in getting a bigger picture, and that's the financial specialist.
And what we understand is that unlike the coaches and the attorneys who need to really work with one party, the financial neutral can be the one of the point persons where everybody doesn't need their own. There may be cases that are complex enough where they're each also consulting with their own accountants, tax advisors, and whatever. But one financial neutral can be a pivot point in these cases and really help move the thing along. They can save time and money by getting people focused on information analysis early in it. Look at the big picture. Nobody has a crystal ball, or who would have guessed housing prices. But to the best they can, look out, get people focused beyond the what's going to happen about support next month into, okay, looking down the road as the kids start moving into college, as you start wanting to scale down at work and look at retirement. Can you afford this house? Is something else a better investment? Can you work at making budgets? Every case doesn't have complex financial assets and asset structures. Every case does have money involved at some level. And often in the cases where there's less of it to go around, the need for precise budgeting work is even higher than it is in the cases where money just isn't the issue. Everybody has some emotional attachment to it, but being able to keep roofs over heads and food going and kids in school isn't the financial pinch for some folks. I think the financial neutral isn't an optional member of the team. It's a key, she or he is a key member of the team to be brought in from the very beginning of the case. And we've committed in the Nevada County Collaborative Divorce Group to having the full team approach, only working with the full team approach. Also, the financial can meet with the parties without the attorneys there or without the coaches there in many cases at a lower hourly rate. It may not be fair, but the attorneys are usually the highest hourly billing rate of the team members. It's smart for cases in which money is an issue, particularly to pay the professional most qualified to deal with your work rather than paying extra to have an attorney who usually isn't cross-trained as an accountant or financial, usually isn't cross-trained as a mental health professional doing that work. Yeah, and not very well at that, absolutely. Developing the long-term forecast is something the financials are trained in, and it's important to get them involved early. They can often chair or facilitate a meeting as the designated neutral, where there are issues of power imbalance between the spouses that the coaches and attorneys haven't worked through enough, particularly early on. It might be smart to set the agenda on meetings that are going to have the financial there and just let the financial run the meeting to keep the power struggles down. One of the things Rebecca talked about was worrying about a perception that somebody's taking sides. We find that does come up with financial neutrals who have to spend more time with the less financially sophisticated spouse explaining the retirement options, explaining the budgeting, explaining gee, you really can't afford this house, how about you look at something more in this price range stuff, because there's just an educational learning curve, and then the more financially sophisticated spouse says, oh yeah, the accountant's on your side. You can educate around that, I think. And I suppose I should do a disclaimer. I haven't actually finished one of these. I've had an awful lot of training. I've got one starting up, so I'm speaking more from what I've been told by people who've actually been on the ground doing it. But it makes an awful lot of sense to me. Anything else about how we can bring the financial in?
I see the financial neutral having an additional role of preparing the disclosures that are required under California law. You need to do a disclosure of your assets and obligations, separate and community. You need to disclose your total incomes. These are things that the financial can put together much easier than any of the other team members. And so that if they can be involved early enough to get that done per the timeline set out in the code, then that's greatly simplifies things. And if we can start with the disclosures, the preliminary disclosures finished before we meet again as a large group, we as attorneys will have a lot better sense of what all the issues really are and can move forward more expeditiously than otherwise.
And having that is important in what I think of as the legal version of informed consent. You have to make medical decisions with a whole lot of information. Making legal decisions should be the same way. And the more information can be brought out early, the better you can know what the real issues are, what the smokescreen issues are, and start working on focusing people on a big picture, what can work for everybody. You can have the juice, I'll take the zest.
Thank you. Unfortunately, when couples divorce, the research suggests that many of the children involved in that process get a couple of minutes of explanation, and that's about it. It sort of happens to them, which can be very, very destructive and problematic. There's another specialist that brings objectivity and a voice for the children, and Rebecca's going to talk about that.
That is the child specialist. When I was preparing for this talk, I looked over some of the quotes that come from children when they're asked. These are normal, healthy youngsters who are asked about their definition of divorce. And a 3.5-year-old said, "Divorce is when mom and dad hate each other and your family is dead." And the 5-year-old said, "It's when someone signs a paper, someone leaves home, and then kids cry." This is a part of what motivates myself, and I think most collaborative team members, to want to find a better approach that changes the experience of children who go through divorce, since there are so many of them. In all other approaches to divorce, children are left outside the process without a voice. Even mediation, children do not have a voice in decisions that directly impact them. The collaborative team approach assures children that their concerns matter and that through their representative, the child specialist, their voices will be heard and their questions answered. The child specialist starts with meeting with both parents to hear their perspectives and concerns, and then meets, usually privately, unless the child is too young, with each child. They have the opportunity to talk about the divorce, their feelings about it, their concerns and worries, with a sympathetic person in a safe environment. They can ask questions and express concerns that might be difficult for them to talk about with their own parents. Often children whose parents are undergoing divorce are aware that their parents are under stress and having difficulties, and they're very concerned and worried about their parents, and they don't want to burden them with questions that might be hurtful to them. Children also have a profound sense of love and loyalty for each of their parents. They don't want to be seen as taking sides. And they also worry that some of their questions may hurt their parents. So the child specialist, they feel free to express the things that are bothering them. And this can also help parents find solutions that help their children in these circumstances. Let's see. When the child specialist, after meeting with the children privately, then they meet again with the parents to discuss the children's needs and concerns, while providing perspective about what is working for the children and what could be improved upon. This information can be useful in developing a plan for parenting from two separate households in the future. The child specialist observations are descriptive in nature, solution-oriented, and never judgmental. And they're usually seen and experienced by parents as very helpful and comforting. This perspective reduces disagreements and introduces potential solutions. And perspectives related to parenting decisions. It also, I think, helps because parents who are tending to focus on their own positions in relation to each other begin to focus more on what will be best for their children, which is really the one thing they have in common, a love for their children and a desire to see them thrive. And I think that coming together in that sense helps to diminish the positional nature that might be happening otherwise. The child specialist's role in collaborative divorce, like other professionals in the process, is confidential. It does not go beyond the collaborative divorce process. This process of including a child specialist goes far beyond the conventional approach an idea that child-related issues can be resolved by a piece of paper laying out the rules for shifting children back and forth between two homes. Such agreements for time sharing do matter, but they're really just the tip of the iceberg.
Thanks, Rebecca. Next, we're going to talk a little bit about the team process and the importance of making a commitment to the team process by each party. First, the process itself. What is a process? A process is a pathway to get from here to there. And the process is really central. So let me talk a little bit about where a couple is when we start at the here. People meet and create a bridge between each other. They make a connection. They fall in love. This is often what it's called. And what is that? That's attraction. It's passion, sex, lust, liking, children often eventually. A connection is formed. And that's often a very exciting kind of time. And then couples, very often, pretty typically actually, bump into some kinds of challenges that they didn't expect, weren't prepared for, whatever. And they come to a crossroads of either finding ways to resolve those differences and the disconnects in a way that affirms and strengthens the relationship, or that begins to move toward disintegration and coming apart. That can be hot war, it can be cold war, it can be indifference. But at that point, the bridge that has connected them begins to tumble, come apart. And that's when couples begin to think about, fantasize about, and eventually talk about and act upon the idea of a divorce. And then, what do you have? You have a disconnect. There's still bridging, but the bridging is filled with pathways of hate, anger, resentment, betrayal, disappointment, and it's a hot, very uncomfortable, or very cold, uncomfortable kind of situation. That's where couples are when they come into a situation where they're saying, we want to come apart. And so the team commits to enter into a process with them that builds another kind of bridge, another kind of connecting, not to recouple, but to connect in a way to honor ongoing interests like children, extended family, financial concerns, in-laws, friends. I don't know how many, I'm sure many of you have experienced what happens when dear friends of yours come apart. What do you say when you run into them in the grocery store? Do you go out and socialize with them anymore? See, their ramifications go all over the place. So the team invites the couple to enter into a different kind of process to get from this very unpleasant place to a place that, again, has some sun in it and saves and retains and conserves the good that was in the relationship before and builds upon that. And that requires that the couple commit to being central in the process. They don't say, okay, you guys, you figure it out and we'll do it. No. They need to participate very actively, each person, in committing to engage not in defending my position, I'm right and you're wrong, but being able to move beyond position, to work with the attorney, to work with a divorce coach, to work with the financial specialist, the child specialist, to gain a larger picture and to participate actively in the process that the people in the team, the rest of the people, are trained and skilled at helping them engage in. So that's what the commitment is involved. It involves often developing a higher degree of tolerance. It may involve forgiveness, it may not, at least civility. Ideally, it can include some acceptance, even perhaps some celebration, that this coming apart is not destroying, but is enhancing new parts of themselves and their lives. That's really the intention of the team, is to take a very difficult situation, help people disengage, re-engage in different ways that are going to be helpful to their children, that are going to allow them to retain and enhance and build upon things that they really value. Okay.
If I can add to that, in addition to the psychological, emotional things that we're hoping to achieve in the process, we also ask the parties to enter into a collaborative divorce contract. And that says very specifically that any of the professionals used in the process cannot be used in litigation. We are asking people to make the commitment to avoid going to court and to avoid threatening to go to court, so that we can have this process proceed without that as a threat in the background. And so the agreement says that the attorneys, if the parties do not continue in the process, they cannot use their collaborative attorneys to represent them if they decide to litigate. They cannot call any of the professionals as witnesses, because all of the discussions that we have are confidential settlement conference discussions, and they may not be used for any reason. However, as I say that, I would also mention that the mental health people, more than anybody, have a reporting obligation in the event they hear about issues of child abuse, elder abuse, potential of injuries happening, and threats. And they can be called in a criminal action, but not in family law action. And so that's something that we talk to people about too. But the contract is important, because the longer you're in the process and the more expensive it's been, it becomes all that much more expensive to the divorce if you then start over with new professionals to go forward with litigation. The only thing you can take from the collaborative process if you drop out is any documents that are executed under penalty of perjury, such as the disclosure documents that I mentioned before, and the stipulations that you actually reached that then became orders of the court. Those things can stay with you, but the professionals will not. And that is a practical way of enforcing the commitment once people think they're ready to take the plunge.
Okay, Marilee's going to talk about the benefits and costs of this process. Marilee, why don't you go ahead?
Well, the benefits are almost too many to mention, especially when you compare it to litigated traditional divorce as one of the options. That's not the only other choice. There are always lots of other choices. The benefit, as Jan pointed out, of privacy in being able to craft these agreements without having your life and what all is being said to and about the other person in public record documents, I think is an important one to stress. The benefits of respect that David talked about, but self-respect, that getting up in the morning, looking in the mirror and knowing you took the high road and did the right thing for the big picture, for people that at one point were passionate about one way or another, especially in cases where there are children, and there is never a, I'll take this, you take that, one of us gets out of Dodge, we'll never see each other approach. And in any long-term relationship, I think the family, parents, grandparents, cousins, joint custody of the friends enmeshment makes that sort of expectation that that's what the divorce is going to achieve really unrealistic. This recognizes it better. I think people, because the couples are primary team members, they're generally better informed. This isn't a process in which they can show up in your office and say, here's my paperwork, call me when it's over. They have to be part of the decision process and take that as responsibility. California law now, at this point, provides under the fiduciary disclosure obligations for full voluntary upfront information exchange without all that messy discovery that we all did for so many years. That's what the code says, but in the real world, I don't know that it's always quite that cheerfully and fully provided. There is a very specific commitment and collaborative process to full, honest, open information exchange. That's very important. You do get people better able to focus on the big picture rather than the individual positions. You get to structure the timing better. There's no way to say how long it's going to take. There never is. And in the meetings that might require 7 people, getting everybody's calendar to take 7 people to lunch at the same time, much less spend 2 hours in a settlement conference, is rarely easy. Everybody who's involved in this is busy. There are very few people who can take just one case at a time and have all day to work on it, and very few clients that would want to pay you to do that. So sometimes there are timing issues, but it'll always be easier to control that timing than to control when you're going to have a courtroom to go out and have a war. And if you don't finish on day 1, then you're going to get day 2 of the war. The child specialist, all of the professionals working on what they're trained to do are giving the clients, the parties, better services for a more reasonable cost. The child specialist is much less expensive emotionally, financially, and every way on getting a result that works for the children. You get to craft unique solutions to the unique family. It's not just go and get the cleaver out and cut the orange in half. You can work with who gets the pulp and who gets the zest. If you take it to court, you're dealing with a arcane, rapidly changing, or at least frequently changing, very specific rule book, very complex rules. Some stranger in a black dress making the decisions for the people instead of people making their own decisions. And it's interesting that when you deal with the rule book, as specific and complex as it is, it's never specific enough that we can give people nice, predictable outcomes. And it's never wide open enough that they can get whatever they think of as justice or fairness. It's just always the wrong solution, I think, in a lot of ways. In the collaborative process, in settlements, too, there's an awful lot that parties can agree to in traditional litigation, and very few traditional cases go all the way to a trial. You just spend an awful lot of money ramping up to one most of the time. But the parties can make better crafted decisions for their unique families. And this is a process that's going to cost less. It's not going to be cheap. It's not going to be free. And as Jan pointed out, if the case falls out of collaboration, then you're doing an awful lot of reinventing the wheel other than some of the paperwork and some of the agreements that have already been done. But you've got more control over the costs. There's one study I know of that indicates that 6 settlement conferences are about the average course of a collaborative case. You know, maybe you can get things together in 3 in the absolutely excellent, everybody's on top of their homework and everything's out on the table early, not real complex case. Maybe it'll take longer. we can't detach this process from the emotional roller coaster that the parties are going through. And they're going to go through their denial and anger and bargaining stage and acceptance phases at the stages they do, each individually. But you can recognize that, I think, better in this process and certainly allow for it in a way that traditional litigation scheduling just doesn't let you do.
Excuse me, I read something that I thought was a really good way of putting it, that litigation attorneys typically spend 95% of their time and your money preparing for something that only happens, which is going to court, in 5% of the cases. Whereas collaborative attorneys can spend 100% of their time working for something that happens 95% of the time. Better use time.
Absolutely. Absolutely. And there's less stress, I think, on the professionals. A lot of us started thinking there's got to be a better way. There's got to be a way not to be part of the solution more than you're part of the problem. I was talking to a judge recently who said, believe it or not, the bench thinks actually that attorneys help more than they hurt. And I thought, boy, oh no. And a judge in this county who says, yeah, I'm starting to sign off on some collaborative stipulations. The way we start the process, it says, okay, here are the ground rules. We're not going to court with anything other than agreements. This is what we're going to do. We all understand it. And he's starting to see some of those. It's very exciting in Nevada County that it was actually last July that Jan and I and another attorney first talked to our bench officers about supporting collaborative process and getting some local rule shifts that would support it better. So it's a little under a year that we've been actively getting together with this. And there are a bunch of cases going. A lot of the people in this room have active collaborative practice cases going. The movement only started in about 1990 in the Midwest with a divorce attorney, Stu Webb, who said there's got to be a better way, and started talking to friends and split out to both coasts. The longest standing group in California, I think, is the Silicon Valley Practice Group in south of San Francisco. And they've had about 4 years with no cases of spreading the word and trying to convince people that there was a better way. We've had under a year with a bunch of cases that are getting started. Partially, the way has been paved for us because there are active movements in many parts of the United States, many foreign countries. It's very popular in Canada. It's becoming very popular in Europe. There are active groups going in England. I understand, but have never actually substantiated, that there is one county in, I think, Wyoming, which is a small population anyway, that actually closed the family law courthouse. They didn't have anything for the family law judge to do. The attorneys got on board. It's wonderful here that of the family law specialists in active practicing specialists in our county, all but one are members of the collaborative practice formation group. And we have a huge influx from our mental health professionals. It's hard to see a downside for this other than the cases that fall out. And there might be some parties who aren't really able to commit to the kind of constructive communication, avoiding the blaming, avoiding the I need to win.
I wonder if I could jump in here on that particular point. I think you have a handout called a preparatory client survey. You just pull that out and look at when Early says there are likely some folks that this might not be a model that might be effective for. Take a look at some of the questions, and I'm not going to read them all, but this is something we ask each member of the couple to go through and honestly respond to. My ability and rate from 1 to 5. Either you strongly disagree or strongly agree. My ability to achieve a successful outcome of the divorce primarily will depend on the decisions I make during the process. If someone disagrees with that, that's a great big hint that that person does not yet see themselves as having much responsibility for how things turn out. On the other hand, someone says, "You betcha." Okay, that says they're likely more ready to participate as an equal party in this. Take another one. Look at number 4. I am not afraid of, nor do I feel intimidated by my spouse. If the answer is, I'm okay with that, that's also a sign that says, okay, this looks like a relationship that can be worked with. If there's fear or intimidation occurring, doesn't mean it's a wipeout, but it does mean that needs some special attention, particularly by the divorce coaches. Okay, it makes sense? Number 9, as a therapist for many, many years, I often have run into situations where one person wants a divorce, the other person doesn't. Well, that's for the person who wants it, they're ready to go ahead. The person who doesn't want it is not ready to go ahead. I've accepted the fact this divorce is going to happen. Sometimes people say, I don't want it to happen, but I've accepted it's gonna. Okay? Well, that's again, gives information. So look through those things. And then there's a way to score that. It's not very fancy, but it gives some ideas to the divorce coach and the attorneys how ready these individuals are to move into this process. Now, it doesn't mean if the score is really low that this isn't a good fit. It does mean that this needs to be discussed very carefully and thoughtfully with each party before proceeding with really signing on to it.
Sometimes that's just a matter of time. The person who has decided to leave has already in their mind gone down that road and prepared themselves and thought about how to go about it. The person who's just finding out 6 months down the line might be in a place where they could do this.
Yes, indeed. Yes, indeed. There's a real process to it. And where there is active abuse, or where there's significant addictions, or where there's untreated mental illness, these factors also play into how actively and successfully each adult can participate in this process. Again, these are not automatic rule-outs. They raise red flags that need to be addressed, explored, discussed. I think it would be fair to say that we believe that most people that are wanting divorce can successfully do this with the appropriate support and encouragement. There may be some couples that wouldn't. This is not a one-size-fits-all. But this process is designed to kind of custom make each divorce, if you will. Rebecca, I think we're going to finish up here and then come to questions, looking at the cost of the adversarial divorce process. And you're going to start with talking about how that can impact children.
And parents as well.
Yes, please.
The costs of an adversarial rather than a collaborative divorce are very high for both parents and children. For parents, waging a battle against a formerly intimate partner can expose one to very profound feelings of betrayal and emotional vulnerability. These feelings often spill over into all areas of life, making one less effective at work or in other relationships, and also it can lessen one's ability to focus one's attention on the needs of one's children. Loss of sleep, health problems, depression, anxiety, all these things are possible outcomes of a very difficult and adversarial divorce. And the conflict generated in this kind of divorce can last for many years, affecting both parents and children in ways that are harmful. Adults often find it more difficult to go forward successfully when they're so much of their emotional energy is wrapped up in anger and conflict. And children are more likely to be exposed to that anger and conflict for a long time to come. That can cause them to lose trust in their parents, in themselves, and in the safety of human relationships. Very high cost.
Attorneys, would you like to talk about the cost on you in working in litigation situations, going to court?
Us?
Yeah.
You mean like ulcers and sleepless nights? And there are some attorneys, I'm sure, who really enjoy litigation. But the vast majority of us really don't. We would love to find constructive ways to resolve issues for people and have them walk away. You look at somebody across the desk and you know that if their child was in the middle of the street, they would throw themselves in front of a truck to save their child. This is the same person who in litigation can cause damage that's almost that serious for their kids. And they don't take any ownership of it. They would comment that kids don't get a whole lot of information about the divorce directly from their parents. The fact is that when people divorce, especially the person who doesn't want it to happen, they're so busy trying to take care of themselves and hold themselves together that they can't even explain it to themselves, much less explain it to their kids. And the research is 11 minutes total that children have in discussing the divorce with both of their parents. And ulcers go away, I think, when you feel like you're helping the kids get through their parents' divorce and make it so that the kids have a chance, at least, of having a good image of what adult relationships can be, even if it means their parents aren't together. And so I'm ready for more rewards in that regard. You open that question up to both of us, though.
The costs, well, I think anybody who's been doing family law for a while understands that there are non-economic costs that can be huge in self-respect, in sleepless nights, and stomach lining to the clients as well as to the attorneys who are being asked to take on this crusader traditional adversarial role. The economic costs are amazing. Litigated cases can blow out the college funds, oh well, blow out the retirement funds, and they run away so quickly. If you're dealing in a traditional litigation situation with somebody who wants to play it by the book and do some things, even some simple things, that are technically correct but way more difficult way. Being able to look oneself in the mirror after getting involved in a fight that gets out of control and thinking, okay, this person can either represent themselves and they are just going to get munched, or I can stay in this at what I need to build in order to support the people I support. And that's going to make it difficult for them to have luxuries, and we're getting to the point in some of them where it's difficult to have necessities and keep the attorney, or I can choose to support these people too and not collect what I need to be paid, which is another bad solution. Being able to control the costs and to spend the money wisely. Talk to your emotional things with your coach. Talk to the child specialist about what the impact on the child is of shifting the parenting schedule. Talk to the accountant or financial neutral about what the tax implications of structuring this kind of budgeting is going to be. Don't talk to me. Spend the money wisely and constructively. And that's going to, and even though it sounds like, okay, used to just have to hire a lawyer, now you have to hire a lawyer and a mental health person for me, plus half of one for the kid, plus half of a financial neutral. How is this less expensive? It's spending the money a whole lot smarter in a more controlled way. I know there are a lot of people who feel that this is, the team approach is only for the high-end cases that can afford it. I think it's even more important for the cases where you have to really watch where the dollars go, which ought to be all of them, but sometimes that's more of a priority than others. I can't predict what the cost of a collaborative process is going to be, any more than you can predict at the beginning what the cost of the litigated process is going to be. The only thing you can predict is it will cost very, very much less. And I think it's on an order of 6 to 10 times less to do it in collaborative process than it would be to take it to a full-scale trial.
And that doesn't even mention all the emotional costs.
Oh, no, I was just doing that.
Yeah.
The emotional costs are more your department.
Right. And there was just one other thing I wanted to mention, going back a little, that divorce research shows that the single best predictor of children having emotional and psychological problems post-divorce is actually the quality of the relationship between the parents post-divorce, so that if there continues to be conflict, there will be emotional trauma.
We know that when, and I think you experience it, each of you, when you're in a situation where one person wins and the other loses, ultimately it's a lose-lose. You've experienced that. Because the person who loses resents so much losing that they find a way to pull down the winner. So collaborative divorce is looking for win-win solutions in which everyone participates in creating solutions that work for them. That includes the children. They're the child specialists, and very much each of the adults. So we've talked about team, process, responsibility, attitudes, intentions, outcomes. Let's throw it open to questions, comments. Laura?
Well, I just want to say, as a clinician seeing a lot of people, kids, adolescents, adults, that the issues, the opportunity to talk at the time of the divorce for the kids is so critical, because if you don't talk, I mean, at least in this process, you have a child specialist, you have people kind of overseeing and figuring out what people's needs are. I have suicidal adolescents who think that everything is their fault when something happens to them, like their girlfriend breaks up with them and this is all their fault, so they have to kill themselves. And if you trace back the origin of that thinking error or cognitive distortion, it always comes from the divorce, because nobody talks about it. And so the kids end up having these delusions of the issues as something is their fault, and they go on in life. And the research at UCLA, the woman whose name escapes me at the moment, did the 30-year study of all these divorced kids. It's so, you remember her name?
Wallerstein.
Thank you. I was thinking Gloria Powell, Judith Wallerstein. It's just a critical moment to check in with these kids so that they don't carry the issues forever. And it's just, anyway, that's my contribution.
Well, seeing the process regularly, this model makes a lot of sense to me. But how do you start with that first question? People come up and say, I don't want to get divorced, he's filing for divorce, give me the meanest divorce attorney you can find. So how do you take that initial, this is how I'm going to react, and explain that they really need to be here?
Okay.
I'll start by saying, go see Marilee. And then my second choice is, why do you want to go to the Barracuda? What do you expect to achieve by doing that? And then I will then go to have them explain what they're attempting to achieve, and then give them Marilee's name.
Where I will talk to them about the three processes and the basic choices and the emotional and financial costs, and ideally get them to see that while there might be some short-term gotcha satisfaction, the long-term, I think probably in every case, but absolutely in cases involving children, whether they're minors or adult children, because adult children tie parents together too. They graduate from college, they get married. Anyhow, that the consequences of that short-term gotcha are going to be a long-term thing, and that shooting yourself in the foot is really never a good move. Whether or not it feels good to get the attention at the ER, it's really not a good move.
And I would like to just comment one more thing, Helen. We all want to help people who come knocking on our doors to understand that a divorce is not the end of the relationship with this other person, no matter how much they want it to be. If there are children, they will be in touch with each other for their children's big events like graduation, their weddings. They'll be standing next to each other in the hospital hallway looking in the nursery window at their grandchildren, who they then could fight about if they wanted. And I say that just because I know of cases in Nevada County where people who started fighting about their children are now fighting about their grandchildren. And stressing, anyway, the image at the nursery window where they have to be relatively close to each other, and have that be okay. And don't build up so much animosity that you can't do that and enjoy this special time. That's all.
The other thing I would think about, maybe not at that moment, but there's an opportunity to talk over a period of time, the corrosive effects of anger on oneself. Anger is so self-punishing. What it does to the heart and the circulatory system and the stomach, and it's immensely corrosive. Forgiveness is one of the most selfish things one can do when you think about it, because it frees us from that corrosion.
And on one of the handouts I give people about the top 10 things to remember to try to keep your sanity during this, says something on the order of harboring resentment is just like taking poison yourself and hoping somebody else gets sick.
Good point, Linda.
Thank you. I wanted to add to when we were talking about the children and the small amount of time that's spent giving them information. Unfortunately, one of the things that we have seen is sometimes there's a large amount of time from one parent giving them bad information. And that's another reason that having the child's own counselor to help them along is just priceless.
As well as, I think part of the coach's responsibility is to help educate the parents about how children really are so identified with both their parents, and you can't make bad comments about their other parent without them taking it in as a message about themselves. And I think that often can help people to restrain themselves. It does take a lot of maturity sometimes to restrain oneself from, when you feel like unfair things are being said. But really, all indications are that down the line, children sort that out, and the parent who spared them that does better in the long run.
Jan, and merely procedurally, since the parties aren't represented by counsel, they opt the collaborative approach, how does it get started?
The question is procedurally, how does it get started if both parties are unrepresented? There's a discussion about the paperwork that needs to go in, and the attorney for the person that's elected petitioner, the first papers to be filed, will prepare those documents as though the party had no attorney at all, and it would get filed, and it gets served. We still have to follow the basic formalities that go along with this. So we have a petition and a summons, and then hopefully a stipulation and an order that goes in acknowledging that they've shifted from the traditional divorce mode into collaborative.
Does that contract, if they get that far, does that contract get filed with the court?
There is a stipulation, and we've got it on, I don't think it's up on the website yet, but it's almost on the website. Almost ready for primetime players. There is a stipulation that does get filed with the court. The court signs off on it, that the parties are electing to take this out. It talks about how the collaborative election can be terminated, what's going to happen and not happen. But ideally, the files are very, very skinny at the courthouse because you've just got the summons and petition, the stipulation into the process, service of the disclosure documents and an agreed judgment. And that's pretty much what the file contains. There might be interim orders along the way. We talk about whether you need to have interim orders for tax consequences of support as opposed to just having some less official agreements for some other things. But that's a case by case.
Would like to underline again, check out the website. There's a lot of information and it links into the international organization that is just chock full of all kinds of information, newsletters and the like. The local group is made up of 20-some individuals. It's been going on since, I believe, September. We meet monthly, and we're always eager for new members, attorneys, mental health, financial, health specialists, to participate and learn more about the process. We're all new at this game, this way of looking at things. We're excited about it. So as a mental health person, I've worked with people trying to clean up the debris from the misfortunes of litigated divorce. So I'm very excited about participating in this. Are there other questions?
Can I just add one more thing to what Sharon was saying? The other thing that doesn't get filed with the court, but that's an important document that is up on the website, is that the parties and all of the professionals sign the principles and guidelines agreement, which lays out what everybody's responsibilities and commitments to the process are. And that's a contract that just gets signed by everybody. It doesn't get filed.
And to correct something that you said, the stipulation is on the website.
Oh, sorry.
It's just not totally correct typographically. And so you have to use a little discretion in how you use that. For example, nobody really wants to divide their martial assets and things like that. Okay, so that's...
Negotiating in good faith, that is the best.
So we do have those problems that haven't all been addressed, but they are all downloadable, as well as, we're posting all of our agendas. We have a lot of information available. And again, it's NevadaCountyCollaborative.com. So
and there are wonderful trainings coming up. There's one next week in Fresno. There's one next month in Sacramento for basic training. There's more advanced training in Park City, Utah. The calendar of events includes the trainings. Redwood Empire, the folks down in Santa Rosa, do a series of 10 classes that cycle every year. They're wonderful on Saturdays. There's a lot of information and resource out there, and Jan keeps up the website and posts all that as we get it.
Any other questions? If you're looking for, anybody want any final remarks? If you're needing mental health credit for participating, please be sure to sign out. Any other final business?
If you missed a handout at the beginning, let me know, and I want to thank you all for coming and spending time.
thank you for inviting us. Everybody needs credit signed out. Yes.
I